Well, hello there, everyone. Thank you so much for joining me. My name is Lior Samfiru, the employment lawyer, and you're here. You just found I was going to say but you found your employment law session. Again, thank you for joining me. I'm Lior Samfiru with Samfiru Tumarkin LLP, and you are here live watching this live stream to learn about employment law, to learn about your legal rights in the workplace. This is the time where you get to ask questions about your workplace situation, where you can ask about losing your job, losing your shifts, your hours, maybe being mistreated in the workplace, bullied, or a human rights violation. This is the time, this is the place to get some answers. Again, I'm Lior Samfiru with Samfiru Tumarkin LLP. You can find us across Ontario, BC, and Alberta. And my team and I help people every single day to deal with workplace issues and to get them resolved. And one of the ways we can do that is right now being here with you and for you to answer questions about employment law, workplace rights, and to tell you what you need to know. So if something's going wrong in the workplace, your boss has done something or said something, or you've been notified that something is coming up, you need to know what this all means. Why not just ask? Ask me right now and I'll tell you, and you can have that information and walk away with a lot more knowledge than you had before. This is a live session. I want a bunch of questions. Last week, tons and tons of questions. A week before that as well. I want to have even more questions today. I want to be kept on my toes so I can get to all those questions and answer every one. Before I get started, I want to give you some contact information as well. If you want to reach me and my team to have a private discussion, to discuss your specific issue in more depth, easy to do. You just go to employmentlawyer.ca. You see that address on the screen, employmentlawyer.ca, and phone number is there. Email address is there. Everything you need to know is there, so you can reach out and contact us. Forms. And by the way, when you're at employmentlawyer.ca, you can also read a lot more about your workplace rights. You can read a lot more about employment law. Such a great tool, a great resource. Again, that's employmentlawyer.ca. But right now, frankly, you don't even need to worry about that. Right now, I'm here live. If you're watching me, you're listening to me talk live, which means I am taking questions. I see some questions are coming in, but please ask yours as well, okay? Sometimes people say, well, I wasn't sure if I should ask you a question, and why? Don't worry about it. There's no bad questions. There is no questions that don't deserve an answer. Every question deserves one. So let's start right now with you telling me what you want to know about. All right, enough of that. Let's start answering questions. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Want to answer questions? I'm going to start doing that right now. All right, first question today from Educational Aid 19. I was dismissed from my job after handing in a medical note from my doctor requesting a leave. I have not been written up or had any negative feedback in my position prior to this, but my employer put dismissed/suspended on my record of employment. They paid me out 2 weeks and now won't answer my calls about the record of employment. I worked there for 2.5 years. Is there anything that I can do? Wow, there's a lot to unpack here, all right? So first of all, you cannot and should not be let go because you have a medical condition. That is illegal, irrespective of the compensation, irrespective of the record of employment. That is illegal. If you're sick and need to be off work, you cannot be let go because of that. That can't even form part of the decision to let you go. So right off the bat here, what we may have is a human rights violation. If you're let go because of a medical condition, that can absolutely be a human rights violation. It's illegal. That means you're entitled to compensation, potentially even your job back in some situations. Illegal, illegal, illegal. Now, let's move on to issue number 2. Even if we forget about the illegality, not that we would, but let's say we did, the question is, what is this person owed? So after 2.5 years, this person got 2 weeks pay. They're owed a lot more than 2 weeks pay. Now, depending on their age, I know their job is an educational aid. They could be looking at anywhere from 3 to 6 months of severance, not weeks, but months. So if you only got 2 weeks and you're owed 6 months, that's now a wrongful dismissal. A wrongful dismissal is a situation when you're let go and you're not paid proper severance. So we have a potential human rights violation here. We have a wrongful dismissal. Man, oh man, couldn't be more illegal if they tried. So here's what you need to do now. Now that we know the answer, educational aid 19, you got to reach me in the office, okay? I want to sit down, have a discussion. I want to find out more details. I want to understand the timing. I want to see what they've given you in writing. And then we can make sure you get what you're owed. We can pursue the human rights issue and, of course, the wrongful dismissal as well. Can't be let go because of your age, because of your medical condition. And certainly you're owed a heck of a lot more than a week's pay per year of service. We need to talk. Connect with me as soon as possible. Let's have that discussion. Thank you. Fantastic question, by the way. Love that question. Very important. Well, that's my answer to that first question. Hopefully, you're seeing how easy it is to ask questions, to get some information, to make sure that you get the help that you need. If you've just joined us and you're wondering, what is this thing going on here? I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And this right here, right now, is my live stream session where I take your questions live about employment law. I just took one, see how easy it is. I want to continue right now. Please ask yours. Keep me busy, all right? I can do more than this. Keep me busy right now. Ask your questions. All right, let's see. Fantastic. Next question is from Red World. Red World. Our company was purchased late last year, and restructuring was done in the company over the last few months. My position was eliminated. I've been working there over 10 years. They gave me 8-week severance plus an additional 4 weeks, total of 12 weeks. After working there for nearly 2 decades, are they giving me less than I'm owed? You better believe they're giving you less than you're owed. Now, I don't know exactly the job you were doing, and I don't know your age, but you could easily be owed over a year's pay. They're offering you 12 weeks. That's less than 3 months. So they owe you 4 times that or more. It could be 5 or 6 times that. Again, that is a wrongful dismissal. Remember, when a business is sold, if you continue working with the buyer, they inherit that service. And that means that when they let you go, if and when down the road, they have to account for that previous service. So that means you're owed severance based on those total years. Yes, you're owed a lot more than 12 weeks pay. I hope you didn't sign anything. So if they offered you 12 weeks and you signed and accepted this, you may now not be able to pursue it. You may have given up your rights, even though you could be owed 5 times that. So you need to reach out to me, Red World, ASAP, as soon as possible in the office. You can do that through employmentlawyer.ca, and I'll help you make sure you get that. Very important questions. 2 questions, 2 wrongful dismissals. Again, just as a reminder, a wrongful dismissal really has nothing to do with the reason someone is let go. A wrongful dismissal is a situation when you're let go and you're not offered or you're not paid your proper severance. Red World was offered 12-week severance when it should be probably 12 months severance. That's a wrongful dismissal with a cherry on top. So that's why we need to do this. That's why you know. And that's why we want to make sure that we get some answers. If you've been let go, chances are you've been wrongfully dismissed. Ask questions. Again, I'm Lior Samfiru, the employment lawyer, live here, answering your questions. Let's continue getting questions. Ask yours in the meantime. All right. Saga World Boss, great name, has a question. I've been at my workplace for 10 years. They put me on a temporary layoff. They say they don't have enough work. What should I do? Well, there's really only 2 options here. The first thing you could do is you sit at home and you wait and see what happens. And at some point, they'll get back to you. Not a great option, but that's option 1. The second option is you can choose to consider your temporary layoff as a termination. In most cases, your employer does not have a right to put you on a temporary layoff, meaning you can say, no, I'm not okay with it. By reducing my pay to 0, I have a right to consider that a termination and get my severance. Now, you've been there for 10 years. Again, depending on your age and position, you could easily be owed a year's pay or even more than that. So your options: do nothing and sit and see what happens. Sure, you can do that. Or you can say, no, I'm getting my severance now. I'm not waiting. I'm not okay with this. I'm going to take my severance and move on. If that is what you want to do, if you want to get your severance, if you don't want to wait and see what happens, don't do anything before you speak to me or my team. Let's have that conversation first and talk exactly how we go about doing that. You can reach me, of course, through employmentlawyer.ca. Again, it's employmentlawyer.ca. Hopefully you understand. Any follow-up questions, I'm still here, so feel free to ask them. Great question, very important question, something that I get asked about quite often. Great question so far. You see how easy it is, by the way, for you. Questions, important questions. They've learned important things about their employment law rights. And I think you're starting to see the theme here that you do have rights. The law does protect you. The law provides options and remedies and things that can be done. Too many people think, well, I can't do anything about it. Well, if you think that, it's probably because you just haven't asked the question. You haven't spoken with someone like me to find out what your rights are. Well, what a great opportunity, because I'm right here, right now. You can ask your question. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm going to continue asking questions. You have a box on the screen. You can type in your question, hit enter, and then I'll see it and I'll read it and I'll answer it. Esther has our next question. My coworkers and I are trying to find a solution to our employer refusing to pay out vacation time. I think you mean vacation pay. We are a small unionized team. We've been told that they will pay us 4% of our gross income of the last year if we do not take our 2 weeks of entitled vacation. Can we fight this? Well, because you're part of a union, in terms of whether you can fight this and how this works with your collective agreement, only the union can answer that. If they've done something wrong, only the union can tell you that, and then only the union is allowed to pursue that. Okay, so one thing that I want you to remember is that in most cases, the law takes a bit of a backseat in a unionized environment. That's why whatever you hear me say on these sessions, or if you hear me on radio or watch me on TV, everything I say only applies to non-union workplaces. If you're a unionized employee, the answer may be different for you, and only the union can advise you, represent you, or help you. Okay, so my advice, I don't know what the answer is in your collective agreement situation. You need to speak with your union and get that answer and get the help. So hopefully that's clear, Esther. Thank you for that. Very, very important that everyone understand that. By the way, before I continue, more questions are coming in, but before I continue answering questions, I want to tell you about another tool. I've already answered a few questions where we talked about severance, and I told you what the severance is. How can you find out right now, in seconds, how much severance you're owed? Maybe you've heard me mention it before. Well, we have a tool for that. It's called the Severance Calculator. To find that, easy. You just go to pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca. That address is on the screen. And when you go to pocketemploymentlawyer.ca, you'll see right at the top the severance calculator. You click on that, and right there, you found it. You can use it and find out in seconds how much severance you should be getting. What is your entitlement? Completely free, completely anonymous. It takes seconds to use. No names, no phone numbers, no company names, no credit cards. It's just there for you. You answer a few questions and it's going to tell you. And you may ask, well, why do I need that? I know what I'm getting. It should be a week per year, or it should be 2 weeks per year. Nonsense. Not even close. It's not a week per year. It's not 2 weeks per year. Check it out. For most people, it's a heck of a lot more than that. So go to pocketemploymentlawyer.ca, click on the severance calculator, and make sure you understand your entitlements. Whether you just lost your job, maybe you're worried about losing your job, or many, like so many people, you just are curious and want to know what your entitlements are. Pocketemploymentlawyer.ca, click on the severance calculator and check it out. But again, right now, I'm still here live. You still have tons of time to ask questions and get answers to your questions. So why not take advantage? I'm going to continue answering, but I want your question as well. Please send it. All right. Masterflex, another great name today, has our next question. Masterflex says, I recently found out that my employer has drastically underpaid me on commission over the last 2.5 years. I got login information to give a full breakdown on my commission payouts, and the numbers aren't even close to what they should be. It looks like I'm owed over $20,000. Should I retain a lawyer for something like this? Man, oh man, absolutely. Because guess what? If you're owed that money and we can show that it's owed, you know what it's going to take for me to resolve it? A letter, one letter. Okay? Once they hear from me, they'll put their head down and say, crap, now we have no choice but to pay it. And we'll get it resolved. You can file a claim with the Ministry of Labor too. They're very, very behind now. I understand it's taking 8 to 9 months for them just to look at matters, not to actually do anything about them. Or we can have a letter sent out tomorrow. So let's get this resolved. If your employer doesn't pay you properly, that's a huge issue. One of the most important things your employer has to do is to pay you what they owe you when they owe it to you. That's the deal. You go to work, you do your job, your employer pays you what they owe you on time. That's it. That's as simple as that. And if your employer is not doing that, the law is not going to allow them to get away with it. Oh, and by the way, if you just found out about this, you didn't know before that you were being underpaid, you can go back the full 2.5 years. Okay? If you just discovered that you were being underpaid from 2.5 years ago, you can go back those full years and get all the amount owed to you. Okay? Reach out to me. Let's have that conversation. Let's get you what you're owed. It's not going to be difficult. All right? So I want you to connect with me as soon as possible. Masterflex at employmentlawyer.ca. Again, employmentlawyer.ca. It's on the screen right there. So you can reach me then, and let's get it done. Thank you. Great question. If you just joined us for the last 15 minutes or so, welcome. Thank you for joining me. I'm Lior Samfiru, the employment lawyer. Let's continue answering questions, and you can ask your questions about employment law, about workplace rights, about your job, your boss, your hours, your compensation, your wrongful dismissal. Ask the question, and I'll answer it. Excuse me. Next question comes to us from Facebook, from Min. I've been on medical leave and am attempting to return to work. My doctor provided my update assessment to my employer, but they are saying that the temporary accommodation I have requested is unreasonable, and they want to demote me. Restrictions aren't permanent, so can they just put me in a different position? So, very good question. Your employer's obligation to accommodate you, the primary obligation, is to accommodate you in the position that you had before. So what I mean by that is if they're able to accommodate you in the position that you had, they have to do it. Now, they have to do that even if it's a bit difficult. They have to do it even if it costs money. They have to do it. And if they refuse, that's a human rights violation. That's a failure to accommodate. Now, if they cannot, they tried, but it's just not possible to accommodate you in your old position. But it's possible to accommodate you in a different position. Then at that point, they can do that. They can look at a different position, even if it's a lower level position. But that's only if they try to accommodate you in your original position and it's not possible. It doesn't exist. So very important. And too often, employers say, oh, no, that's just too difficult. When it's not, when they can still actually accommodate you. So if you believe your employer is able to accommodate you, but they're choosing not to, you got to reach out to me as soon as possible. Okay? You could do that through employmentlawyer.ca. Let's have that discussion, and I'll help you. All right? Remember, that duty to accommodate, so important. Too often, employers breach that obligation. They don't want to work hard to accommodate. That's illegal. Thank you for that question. Let's continue answering. A bunch of questions have come in. You still have time to ask yours, so please do so with me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And the next question today is from Philip. When having a meeting with an employer during a dispute, is it better to have things in writing or recorded audio conversation? Well, I mean, if you're asking me what's better, certainly a recording is better. I would like to have both, frankly, right? Why not? Because if something of value is said in a conversation, I need to see that. I would want to see a record of it. So yes, you can record a conversation. It is legal to record a conversation. It is legal if you're part of it. Your employer doesn't even have to know. If you can also then follow up in writing and send an email to your employer confirming what was said, even better. Then you're really, really covered. Okay. So you never want it to be a he said, she said, because if your employer says something it shouldn't, and later on you call them on it, they're not going to admit it. Oh, I never said that. What are you talking about? That's nonsense. Well, here's the proof. You got it. So that's why we need that proof. Recording is fine. Writing is fine. Having both, best thing. Hopefully that makes sense, Philip. Any follow-up questions, issues, problems? Still here, not going anywhere. Ask. All right. Thank you for that. Good. I have a question from LinkedIn user. Okay, very good. It says, hi, Lior. My husband was laid off this morning due to a RIF. He has been there close for 9 years, and they offered him 33 weeks. Based on his tenure, age, profession, the calculator states he would be owed 12 to 14 months. Well, that's why we use the calculator. Now you know what he's owed, and the next step, it's not complicated, right? Next step is you reach out to me, and myself, my team will help him get what he's owed. 33 weeks, call that 8 months. It's less than 8 months. He's owed 12 to 14 months. That's potentially another 6 months pay. That's a big, big difference. So that is a wrongful dismissal. So if your husband was let go and he was offered 6 months less than what he's owed, it would be wrong to accept this. Certainly not without having that discussion, having a conversation, and let us help him get what he's owed. The one thing I also want you to remember is this. Once we get involved, in the vast majority of cases, it's not difficult, complicated, long to get it resolved. Once the company hears from us, they'll speak with their own lawyer who will tell them, yeah, Lior, his team, they're right. You owe them more money. We negotiate proper severance and we move on. So that's why you reach out to me. You've used the calculator. By the way, everyone, that is an example as to why you use the calculator. He wouldn't have known. He was offered 33 weeks. He went to the severance calculator, took him a few seconds, and he realized, holy cow, it should be 12 to 14 months. That's why I use the calculator. Of course, you can find that at pocketemploymentlawyer.ca. That's our severance calculator. Okay, hopefully that makes sense. Thank you for that question. Let's continue. By the way, if you're here for the last few minutes, I'm Lior Samfiru, the employment lawyer. You still have time to ask questions, to get questions answered, to get some help and support. Just ask the question. Don't hesitate. Let's make sure you get answers. All right. Our next question is from Marina. Marina has our question next, and she says, if a job is offered by a small employer or an international company registered in Ontario, how can you check the legitimacy of the employer? How to avoid fraud and identity theft? How do we check the legitimacy of the company? Well, honestly, you would want to go online and do search. There's also business searches you can perform. We have access to that, but you can read reviews of the company on Google or on Glassdoor or on LinkedIn. Do that homework. Okay, ask questions. There are fraudulent companies where they're not really companies. They're trying to steal identity. Very rare. Okay. But you can do your homework. If you're not sure, we can perform a search for you, a corporate search, and find out more about the company. But honestly, if you do your homework online, in the vast majority of cases, if you spend a good 10, 15 minutes, you'll be able to get answers. So that's the best advice. If you have some suspicions, don't do anything until you do that research. All right. Thank you for that question. Let's continue. Becky has our next question. She says, my husband was laid off. Okay, we've answered that question. Sorry, Becky, you had it before as LinkedIn user. I answered the question. Hopefully you got that answer. So very important that your husband reach out to me as soon as possible to get some answers and some help, because he's owed much more severance than the 33 weeks that he was offered. All right, let's see. You still have a few more minutes, guys. So if you want to get an answer, don't regret it later. Don't say, man, I wish I would have asked the question. I would have felt better. Feel better now. Ask the question. Let me help you. Next question for us today comes from Swimming7629. My employer is looking to change my compensation package quite drastically, to the point that it's not feasible to remain with the company. It's more than a 15% reduction. I'm looking for new work, but I would like to know if I'm entitled to any kind of severance. So the answer is yes. with a significant pay reduction, you may be able to consider your employment as being terminated. We call this constructive dismissal. What that means is that by your employer changing your pay in such a big way, it's as if they've terminated the employment. They've broken the deal. And that allows you to treat that as a termination and get your severance. Now, to do that, you would have to leave. And you need to leave ASAP. You can't really wait. If you wait, you're going to be considered to have accepted what your employer did. And then you don't get severance and you're kind of stuck and you've given them the right to do it again. So if you accept that reduction by staying quiet and just continuing to work, number one, you give up on constructive dismissal, but you give the company the right to do it again and again because you created that precedent, okay? So very, very important to remember that. If your employer reduces your pay, yes, it's a constructive dismissal if it's a significant reduction, but you got to act quickly. So what I'm going to say to you, Swimming 7629, call me ASAP today, okay? As soon as possible. Let's have that conversation and let's figure out how to get you out of there with severance. Now, it's okay if you don't want to do that. You're just going to wait till you find another job. That's okay. But you may then be giving up the right to get your severance at all. All right? So keep that in mind. And feel free to connect with me as soon as possible. You can do that through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's see. I have time here for another question. Skater Dude, love it. Skater Dude says, I just got fired today and was told it was because the company is restructuring and eliminating my position. They said I would keep my benefits till the end of March and receive 1 week's pay and 2 days vacation I had accrued. Is this normal for being under 1 year of employment? No, it's not normal. Here's what I want you to know. Short service employees with 5 years seniority or less, are actually treated disproportionately better than long service employees. So a short service employee is treated disproportionately better than a long service employee. So you have under 1 year of employment. Now, I don't know your age. I don't know what kind of a job you're doing, but you're probably going to be owed a few months, not days, not weeks, a few months of severance. So again, depending on, there's going to be a difference if you're 20 versus if you're 60. There's going to be a difference between if you're working on a minimum wage job or if you're an executive. But either way, it's going to be a heck of a lot more than a week's pay, which is what they've offered you. All right. So for that, you can find out right now. You don't even need me to tell you. You can go to the severance calculator. You go to pocketemploymentlawyer.ca. Hey, look at that. The address is on the screen right now. And find out how much you're owed. But so many people think, well, I've only worked for a few months, or maybe I've worked for a couple of years. So what am I going to get if they let me go? Probably not much, right? No, not even close. It is much. You're going to get severance measured in months. And by the way, the length of severance sometimes can be more than the length of employment. In other words, in some cases, you can get more months of severance than the months you actually spent working. So if you work for, 4 months, and you're in a senior position and you're in an older, and maybe in a job that's difficult to replace, you could be owed more severance than that, more than 4 months. You could be owed 6, 8, 12 months severance, even though you only worked for 4 months. So you always use the severance calculator, or you call me, and please do not accept, whether you work for 6 months, for a year, for 55 years, whatever it is, if you lost your job, you should not ever accept that severance offer. There's a 90+% chance that whatever you've been offered is not even close to being adequate. You know what to do now. You reach me and my team through employmentlawyer.ca. Guys, that was a fun session here today. Thank you, by the way, for joining me. We're going to be keeping a close eye on what happens in the U.S. With the tariffs that President Trump has threatened to impose on Canada. The unfortunate reality is that if those tariffs are imposed, it's going to impact jobs across Canada. And it's not your fault as an employee, but I want you to remember that if your job gets impacted because of tariffs, your legal rights, your severance entitlements don't get impacted. You still get severance. In fact, if it's a bad economy, you're maybe even be owed more severance than you would have in a good economy. So if those tariffs happen and you lose your job, let's make sure you get what you're owed, because it may be more difficult to find another job. you got to reach me as soon as possible through employmentlawyer.ca. Hopefully it doesn't happen, but if it happens, we've got your back. Guys, thank you so much for joining me today. Always a pleasure, always a privilege. You know what to do if you want to continue the conversation with myself and my team off social media. Again, you just go to employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. Look forward to connecting with you again very soon. In the meantime, employmentlawyer.ca. Thanks, guys. All the best.